been looking forward to this session since the beginning of our planning. I get to have the honor of introducing one of my dearest friends in the profession. I have worked with Helena Silverstein for a quarter of a century. Can you believe that? It sounds even more than 25 years. We have been across the hall from each other for years. Haven't seen each other in person, I think, for about 3 years with COVID. Somehow we're doing that. Helena Silverstein is the newest occupant of the Thomas Roy and Lura Forrest Jones Professor of Government and Law chair, and she is the department head for the Government and Law department that I'm a part of. She was educated at the University of Washington, has a PhD, and then went to, she has her master's, her bachelor's was at the University of Washington. If I got that backwards, Helena, your bachelor's was at Penn, University of Pennsylvania, and her master's and PhD were at the University of Washington. She is an expert in the legal process, constitutional law, and social movements, but she is a uniquely respected and high-powered expert on abortion law and personal autonomy law. She has authored 3 books, The Supreme Court by Greenwood Press in 2021, Girls on the Stand, How Courts Fail Pregnant Minors, 2007, and then her initial book was Unleashing Rights. It was The Law, Meaning, and the Animal Rights Movement. And we share the same students. And so it's not uncommon for me to have students come into my class and say, we understand what you're saying, but this is what Professor Silverstein taught us. And so Helena and I have conversations back and forth through our students. She is a joy to work with, and I'm always ready to listen to anything she has to say about this topic because I learn from it and it helps my teaching and education down the road. Helena, thanks very much for joining us.
Thank you so much, Bruce. Those are such kind words. And why don't we just go ahead and jump in? As you all surely know, last June, the Supreme Court overturned Roe versus Wade and Planned Parenthood versus Casey, 2 of the key precedents that governed the right to abortion. You probably also know that in the 2022 ruling in Dobbs versus Jackson Women's Health Organization, but that didn't come out of nowhere. It was a long time in the making. It followed decades of social movement activism, of heated electoral politics around abortion, massive fundraising campaigns and lobbying campaigns, heavy investment in both litigation and legislation, and of course, contentious judicial nomination and confirmation battles. While Dobbs last summer was the culmination of a concerted campaign to reverse Roe versus Wade and the right to abortion, it is by no means the end of ongoing battles over privacy rights, over reproduction, over personal autonomy, bodily integrity. And we're seeing those battles already playing out in other branches of government, but also in the courts, in the federal courts right now. And we'll talk a little bit about some of those battles that are currently playing out. Those battles won't be limited to abortion or even medication abortion. They will implicate such things as contraception, managing medication during pregnancy, and they may reach more broadly into matters of sexual intimacy and marriage equality. So there's a lot of implications. I'm not going to go through all of that. So my goals for this evening are to provide you with an overview of some of the key legal precedents that presaged and grounded what would become the constitutional right to abortion in Roe versus Wade. I'll be relatively brief in outlining that, but I want to give you at least a little bit of context. I'd like to then explain the ruling in Roe and Planned Parenthood versus Casey, and how Planned Parenthood versus Casey modified Roe but still sustained the constitutional right to abortion. And then I want to focus on the ruling in Dobbs and touch on not just the majority opinion, but also some of the concurring opinions and the dissenting opinions. And as I go through that sort of line of stuff, I will talk about some of the other cases that have come through over the years, but I will mostly focus on Roe, Casey, and the Dobbs decision. Then I'd like to turn to the implications for abortion, contraception, sexual intimacy rights, marriage equality. Again, just touching on those, and I'll also highlight a little bit about the battle that's presently going on, unfolding regarding abortion medication. So those are the main things that I'd like to do. But before I jump into those, what I want to start off with is highlighting levels of judicial scrutiny, because the levels of judicial scrutiny that the court has used over the years, not just in the abortion context, but in other contexts, are an important part of the way in which the court analyzes a number of different kinds of things. And so I thought I would start with a brief overview of judicial scrutiny. So the last bullet point there is actually where I'm going to start, and then we'll go through back to the beginning of the key legal precedents leading up to Roe versus Wade. All right, so beginning with judicial scrutiny. Judicial scrutiny, as you may know, in the context of constitutional law, it's a standard of review. It's a way in which the court examines laws and actions to assess their constitutionality. And when the court applies judicial scrutiny, what it's doing is it's examining with a judicial lens whether or not something meets constitutional muster. And the court basically uses different levels of judicial scrutiny for different kinds of cases. And as it has come to be used by the court since the New Deal era, when it really first started, and then especially since the 1960s, the tiered standard of review ranges from a very, very high bar, a high, very skeptical, searching kind of judicial scrutiny, all the way down to a really low bar, which is a very deferential approach to examining constitutionality of laws and policies. And what we'll see in the context of abortion is that the court has changed over the years its level of scrutinizing state and federal regulations of abortion. And where we are now is at the lowest level of judicial scrutiny in the aftermath or because of Dobbs. So again, just briefly on judicial scrutiny, the origins of judicial scrutiny essentially date back, this terminology, judicial scrutiny, date back to U.S. versus Caroline Products, a 1938 case that involves the transportation of skim milk in interstate commerce. And in the case, the Supreme Court held that a federal law banning interstate transport of skim milk was constitutional. And what the court did is it applied the lowest level of judicial scrutiny, basically saying, if the government regulation is reasonable, then it is constitutional. It's only going to be unconstitutional if it is an unreasonable, arbitrary kind of regulation. But in that case, in the famous footnote 4 of U.S. versus Caroline Products, the Supreme Court sort of suggested that there might be some cases where it would heighten the level of scrutiny, where it would be more searching and investigating of laws passed by Congress, for example. And what the court said is that, especially in cases where the government is regulating fundamental rights, fundamental constitutional rights, or where the government is singling out discrete and insular minorities for different treatment, in those cases, the court might be inclined to heighten the level of scrutiny, to be more searching of the government's justification. And so, as a matter of fact, over the many years following U.S. versus Caroline Products, the court did indeed create a set of tiered levels of judicial scrutiny. And so, without going through all of those cases, let me just give you a broad sense of judicial scrutiny. So a quick overview again. Judicial scrutiny is a two-pronged test. When the Supreme Court applies judicial scrutiny, it is it's inquiring into the government interests behind a particular law or policy, and it's inquiring into the means that are used by the government to advance that interest. So this is where you get the two-pronged test. And then, as you can see on this next slide, what the court is doing when it's applying different levels of judicial scrutiny is it requires a higher bar for each of the levels of scrutiny. So if the court is applying strict scrutiny, which it applies when the government regulates fundamental constitutional rights, or when the government selects out a protected class for different treatment, in particular classes based on race. If that is being regulated by the government, the court is going to, according to strict scrutiny, demand that there be a compelling government interest to justify the law, and it's going to require that the means that are used to advance that interest be narrowly tailored to the achievement of that compelling interest. And the court says if there isn't a compelling interest and if the means are not narrowly tailored, then the law won't be constitutional. But if the government can show a compelling interest to, for example, restrict a fundamental right or regulate a fundamental right, and it uses narrowly tailored means to do so, then the bar might be surpassed and the law would be constitutional. At the lowest end of the tiers of scrutiny is the minimum scrutiny, the reasonableness test, the rational basis test. Those are all terms that define the lowest bar. At the lowest level, all the government needs to do is say that show that there is a reasonable, rational, legitimate justification or purpose behind the regulation, behind the policy, and that the means used are rationally related to that interest, or at least that there are some means used that we can imagine being rationally related to the interest. So the bar is really, really low, and minimum scrutiny is applied to government regulations of anything that are not constitutional, fundamental constitutional rights. And then at the intermediate level, intermediate scrutiny, which, for example, the court has applied in the context of regulations that single out or treat people differently based on sex, based on gender. There, the court requires an important government interest and means that are substantially related to the achievement of that interest. Okay, so that's basically, broadly speaking, there are lots of caveats, but that's basically judicial scrutiny in a quick nutshell. So let me move on from there. I'll harken back to that as I go through some of these cases, but let me move from there into the basic, really brief discussion of the pre-Roe background cases and precedents. So I'm sure you know that the Constitution has a number of privacy-related provisions, even though the Constitution doesn't explicitly protect a general right to privacy and certainly doesn't explicitly speak to abortion or bodily integrity and bodily autonomy concerning abortion, for sure. But there are these number of provisions in the Constitution that are seen as touching on privacy interests. First Amendment, Third Amendment, Fourth Amendment, and you can see them on here. But for example, search and seizure, protections against unreasonable search and seizure, protections against quartering of soldiers in people's homes, protections against self-incrimination have privacy components to them. And in the long history of the Supreme Court decision-making around lots of different amendments, First, Third, Fourth, 14th, Fifth Amendment, there have been a number of cases where the court has identified some key kinds of privacy-related interests. Again, I'm not going to go into this in all that much detail. These are just kind of examples of privacy-related precedents that presage Roe versus Wade and that provide a foundational precedential ground that built up to Roe versus Wade. But for example, from the Fourth Amendment protections against unreasonable searches and seizures and Fifth Amendment liberty and due process guarantees, the Supreme Court began in the 1900s to advance the notion that where individuals have a reasonable expectation of privacy, they're entitled to be free from unreasonable government intrusion. You can see that kind of conceptual argument in Katz versus United States in 1967, also Terry versus Ohio, 1968. The court has identified certain privacy and autonomy interests that grow out of the First Amendment. For example, in Stanley versus Georgia in 1969, this idea, I have a quote from the case on the slide. If the First Amendment means anything, it means that a state has no business telling a man sitting alone in his house what books he may read or what films he may watch, right? There's a privacy idea that is being captured in a case involving obscenity and pornography, right? In addition, starting much earlier than the 1960s, in the 1920s, the court began to apply the 14th Amendment due process clause by identifying personal privacy rights and freedoms from government intrusion into areas of marriage, reproduction, and child rearing. And so again, for example, Pierce versus Society of Sisters, that's a case where the Supreme Court found unconstitutional an Oregon law that required public school attendance because it interfered with the liberty of parents to direct the upbringing of their children. And in Skinner versus Oklahoma in 1942, the court talked, among other things, about the importance of marriage as being central civil right of man, even though the Constitution doesn't explicitly mention a right to marry. That case was about sterilization, but the argument was grounded on this idea of marriage and procreation being fundamental civil rights. So prior to Roe versus Wade, there's that line of cases, many other cases, but two of the key cases involving privacy that really presaged and provided precedent for Roe versus Wade were Griswold versus Connecticut, and then a second case, Eisenstadt versus Baird. So I'll go into those in a little bit more detail, but I'll be relatively quick here as well. Griswold versus Connecticut involved an 1879 law that prohibited the use of contraception and the dissemination of information on the use of contraception. By a 7-2 majority, the Supreme Court, in an opinion written by Justice Douglas, ruled that the Connecticut law violated a married couple's constitutional right to privacy. In particular, the Supreme Court ruled that there is a right to privacy that emanates from other explicit rights in the Constitution. And so we know there's not an explicit general right to privacy that's written out in the Constitution. But what Douglas argued in his majority opinion for the court was that all sorts of implicit rights are embedded in the Constitution. All sorts of implicit rights emerge out of the emanations, the penumbras of the explicit rights in the Constitution. And he notes, like, there's, like, for example, the right to educate a child in school is in the school of a parent's choice, is not mentioned in the Constitution, but it's protected by the Constitution. The right to study a foreign language is not explicit in the Constitution, but it's protected by the Constitution. The First Amendment protects those kinds of rights. And so what Douglas argued on behalf of the court in Griswold versus Connecticut is that the right to privacy in marriage to choose contraception is one of these rights that emanates from other provisions in the Constitution. He says, so it is with privacy. While there's no explicit grant of privacy in the Constitution, the right emanates from other explicit rights, and it protects the right of married couples to use contraception. I have a quote up here from the opinion: governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. That language in the opinion, it's not exactly strict scrutiny, but it is approaching portions of strict scrutiny, because what Douglas is saying here is that even if the government has a legitimate, strong purpose to regulate, that doesn't mean it can just use willy-nilly sorts of methods to achieve that purpose. If those methods sweep so broadly and scoop into the government's purview all sorts of protected areas of freedom and privacy, that violates the Constitution. In addition, something to note about Griswold is that, of course, it protects a kind of general right to privacy. It finds that there's a general right to privacy in the Constitution, but because the case is only about married couples, it's really, and because the language in the opinion also focuses very much on married couples, it really only applies to married couples seeking to use contraception. And so it's the privacy interest of married couples that ends up being the focus of Griswold versus Connecticut. In the next case that I'm talking about, Eisenstadt versus Baird, in 1972, 7 years later, the court broadens out the right to privacy to incorporate and include the rights of non-married people to use contraception. And interestingly, in Eisenstadt versus Baird, the court relied on the lowest level of judicial scrutiny, but it was also applying equal protection analysis. So not really so much privacy analysis, but equal protection analysis. What the court held in Eisenstadt versus Baird was that married couples have a right to contraception protected by the Constitution. Treating unmarried people and not letting them get contraception is a form of unequal treatment. And there isn't, and the court treating married people and unmarried people differently doesn't rise to the level of a protected class that would trigger a higher level of scrutiny, according to court at that time. But the court said that really it's not reasonable to treat married and unmarried people differently with respect to the right to contraception. So the court held that the right to obtain contraceptives must be the same for married and unmarried individuals. So all of that takes us to Roe versus Wade and the constitutional right to abortion that was established in 1973 in Roe versus Wade. I'll walk us through the ruling a little bit more slowly than I've been sort of flying through these other ones. 7-2 opinion authored by Justice Blackmun. The case involved a Texas law that banned abortion except in cases where the mother's life was in danger. Texas was, of course, not alone as a state that was restricting abortion at this time. Most states in the country had pretty restrictive abortion regulations, though by the late 1960s and early 70s, a number of states had started to liberalize their abortion laws. The majority opinion in Roe versus Wade relied quite heavily on the earlier precedents, especially Griswold versus Connecticut. And after an extensive discussion of the history of abortion law and abortion practices and regulation, Justice Blackmun basically accepts the ruling in Griswold that the Constitution grants a fundamental right to privacy, and that it grants it based on the 14th Amendment due process clause, the liberty component of the due process clause of the 14th Amendment. And he says that that fundamental right to privacy that is part of the Constitution, it extends to the abortion decision. He says, and I'm going to quote here, the right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force upon a woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There's also the distress for all concerned associated with the unwanted child, and there is the problem of bringing the child into a family already unable psychologically or otherwise to care for it. In other cases, as in this one, the additional difficulties of continuing stigma of unwed motherhood may be involved, end quote. So what Blackmun there is noting is that forced pregnancy, forced continuation of pregnancy has the potential to cause real harm to women who do not want to continue with pregnancy. So there's a fundamental right to privacy. It extends to abortion, is the key component of Roe versus Wade. But Blackmun and the majority of the court are quite clear that the right to privacy and the right to abortion are not absolute, that no constitutional right is completely absolute, and that just like other fundamental rights, they may be subject to some regulation that may be acceptable regulation. And Blackmun here is very clear in pulling on strict scrutiny as the standard of review. He says, and again, I'm quoting, where certain fundamental rights are involved, the court has held that regulation limiting these rights may be justified only by a compelling state interest, and that legislative enactments must be narrowly drawn to express only the legitimate interests at stake. So fundamental right to privacy extends to abortion, not absolute, can be regulated if there's a compelling interest and the means are narrowly tailored to the achievement of that interest. That's pretty much the heart of Roe versus Wade. Blackmun continues to say the state does have interests in regulating abortion in some contexts. Those interests have to do with protecting the health of the woman and interests in the potential life of the fetus. But those interests aren't compelling at the moment of conception. They become compelling later on in pregnancy. And this is where Blackmun and the majority opinion gets to the trimester framework in outlining the points at which the state regulation becomes compelling enough to justify state regulation of abortion. So here's the trimester framework as Blackmun lays it out in his majority in Roe versus Wade. Essentially what Blackmun says is that with respect to the state's interest in protecting a woman's health, that interest doesn't become compelling until the beginning of the second trimester, because in the first trimester, abortion, very safe, much safer than continuing with pregnancy, and the state doesn't really have a good justification, a compelling justification to interfere with women's choice of abortion in the first trimester. Second trimester and moving forward through pregnancy, abortions become more challenging, medically speaking, more difficult. And there, the state has an interest in regulating to protect the woman's health. So that's how the compelling interest sort of functions with respect to the woman's health. With respect to the state's interest in the unborn, Blackmun says, there's no evidence that the Constitution deems the fetus to be a person with constitutional rights. That doesn't mean that the state doesn't have an interest in the potential life of the unborn. But that interest doesn't become compelling, according to Blackmun, until the moment when the fetus can survive outside the womb, the moment when the state can actually enact its protection of the fetus outside the control of the mother, outside the body of the mother. And so Blackmun says that that point is the moment of the beginning of the third trimester. And so the state's interest in protecting the life of the unborn doesn't become compelling until the third trimester. And here, essentially what Blackmun says and what the court says is that prior to the third trimester, states can regulate to protect women's health, but they cannot ban abortion before the third trimester. Once the third trimester begins, moving forward in pregnancy, the state may, if it wants, ban abortion to protect the life of the unborn, but it cannot do so without providing protections for the woman's health and life. So that's Roe versus Wade. There's a companion case that we often forget about. That's part really of the Roe versus Wade kind of, or the right to abortion analysis. That's Doe versus Bolton, handed down on the same day as Roe versus Wade. Again, very briefly here, because the main points of Doe versus Bolton have to do with this health issue. What Doe versus Bolton says is that state restrictions of abortion in the second and third trimesters must provide exceptions for the preservation of the life and health of the mother. And Doe versus Bolton says that the meaning of health, like protecting the health of the mother, includes health involving physical, emotional, psychological health. So it's a broad conception of health, so that if the state is going to regulate abortion or ban abortion once the third trimester starts, there have to be exceptions to protect a woman's life and a woman's health broadly construed. So after Roe versus Wade is handed down, state legislatures began to pass various restrictions on abortion, really to test the limits of Roe versus Wade. Congress also passed some regulations as well. And then the court responded in a series of cases through the 1970s and through the 1980s, basically reaffirming Roe versus Wade mostly through those years. So states passed regulations restricting funding of abortion. The federal government, Congress passed the Hyde Amendment to restrict federal funding or government public funding of abortion in most cases. Those are the sets of regulations that the Supreme Court actually upheld. But most of the other regulations that states tried to pass, most of them were deemed unconstitutional under the Roe framework. And that included regulations like requiring hospitalization for abortions in the first or second trimester, requiring waiting periods and informed consent requirements, requiring parental involvement, requiring spousal notification for abortion, requiring ultrasounds, requiring viability testing. Lots of those were deemed unconstitutional. Another one that was deemed constitutional was parental consent and involvement requirements, as long as they contained a judicial bypass or an alternative route around parental involvement. There were also efforts to ban certain types of abortion methods during this period of time. And like I said, many of these were deemed unconstitutional under the Roe framework. But the changing composition of the court through the 80s and then into the early 90s really began to press on and ultimately alter constitutional interpretation. And that gets us to Planned Parenthood versus Casey. But before I jump to Planned Parenthood versus Casey, let me just note the following about the legislative and political activity in the aftermath of Roe versus Wade. A lot of that activity was very political and very partisan. Part of what happened in the aftermath of Roe versus Wade is Republican Party began to strategize to try and draw Democrats away from the Democratic Party around the abortion issue. And in particular, began to try to appeal to Catholic Democrats. And then later in the 1970s and into the 80s, began to try to develop support among Protestant evangelicals, pulling them into the Republican Party around the issue of abortion. And when Roe versus Wade was handed down, Republican Party membership wasn't like opposed to abortion any more than the members of the Democratic Party were. Like, there was not a very significant partisan divide around the abortion issue. There became a partisan divide around the abortion issue, and that was in part a strategic decision by Republican strategists to try and create some party realignment. So I wanted to mention that, wearing my political science hat for a second there. Okay, so Planned Parenthood versus Casey in 1972. This is a 5-4 decision, although really it's much more complicated than that. It's a plurality decision. The court was quite divided, with liberals on the left, more conservatives on the right, and then a group of sort of more moderate justices, some of which were a little bit more liberal on abortion, but not so much, who formed this joint plurality opinion. When Planned Parenthood versus Casey came before the Supreme Court, or, when the court was considering the case, a lot of people expected the Supreme Court to overturn Roe versus Wade. The signs seem to be pointing to the court having a 5-member majority ready to overturn Roe versus Wade. That didn't happen because of the formation of this joint plurality, and because O'Connor and Kennedy surprised a lot of people in terms of where they landed on the abortion issue. Planned Parenthood versus Casey took up a Pennsylvania statute that regulated abortion. It had an informed consent requirement, 24-hour waiting period, parental consent requirement, and a spousal notification requirement for married women. The joint plurality opinion in Planned Parenthood versus Casey ultimately reaffirmed what they called the central holding of Roe versus Wade. They defined the central holding of Roe versus Wade in terms of the bullet points that I have on this slide. In particular, what the joint plurality opinion held was that what Casey held was that Roe held that the right of a woman to choose abortion prior to viability and to obtain it without undue interference was the centerpiece of Roe, right? That the idea was that, according to the plurality here, the idea was that Roe said women have a right to choose abortion before viability and to get it without undue interference. And coupled with that was the second key central holding of Roe, according to the plurality here, that the state has the power to restrict or ban abortion after viability if the law has exceptions for women's health, okay? But then they added this third piece, which they deemed to be a central holding of Roe versus Wade. The way that they crafted this was that they said that the state, according to Roe, the state has a legitimate interest throughout pregnancy, from the moment throughout pregnancy.
Come on in.
In protecting women and the fetus, women and the unborn. So they use the word legitimate interest, right? So they're not saying that the court in Roe held that there was a compelling interest or that the state had a compelling interest throughout pregnancy. They lowered it to legitimate interest, but they're basically saying that Roe acknowledged that the state has interests throughout pregnancy in both the life of the mother and the life of the unborn. So this is how they termed the central holding of Roe. And they went on to say that abortion under precedent of Roe is protected by the 14th Amendment due process clause. It's protected by a liberty interest. It's protected because, and this is their language, it involves the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy. So they're acknowledging and reaffirming this right to abortion that Roe established. But they say abortion is a unique act. It affects others, the mother, the physicians performing abortions, the father of the unborn, people in the world who care about the abortion issue, and that the state has interests that permit the state to regulate. So there are these competing interests that the court acknowledges, that is the joint plurality opinion acknowledges, and it emphasizes that abortion is a unique act. It's an unusual, it's not like other kinds of acts. And in balancing the competing interests, what the joint plurality opinion says is that the trimester framework established in Roe is not a good balancing method. And really strict scrutiny doesn't work either in this context, essentially. So that the plurality in Roe completely rejects the trimester framework, and it moves completely away from strict scrutiny in the context of abortion. And instead, what the plurality does is it says the viability line is the line for determining when the government can ban abortion. So prior to viability, not the third trimester, prior to viability, women should be able to choose abortion if they want, without undue interference. But after viability, the state may ban abortion as long as it maintains protections for women's life and health. But in addition, in terms of evaluating when the state can regulate abortion, what the court said is we're not using what the plurality says is we're not using strict scrutiny, we're using the undue burden standard. Under the undue burden standard of the plurality in Casey, the court says not every law that makes a right more difficult to exercise is automatically an infringement of that right. Only when state regulation imposes an undue burden on a woman's ability to make this decision does the power of the state reach into the heart of liberty protected by the due process clause. And the way that the court cashes out what undue burden means is the court says, quote, state regulations may not have the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. So if the state imposes burdens, imposes hurdles, imposes some costs on women, that's okay, as long as they are not substantial and as long as they are not intended to impose a substantial obstacle. And among the things that the plurality argues in Planned Parenthood versus Casey is that the state's interest in protecting the life of the unborn begins from the moment of conception, and that the state can act on this interest, again, as long as it doesn't impose an undue burden on women, as long as it doesn't create a substantial obstacle or intends to create a substantial obstacle. But the state can prefer pregnancy and childbirth over abortion. The state can express its preference for childbirth over abortion. It can try to encourage women to have children rather than go through an abortion. It can let women know that there are philosophical and social arguments against abortion. It can do all of those things without imposing an undue burden on a woman seeking an abortion. After Planned Parenthood versus Casey, what happened was that states continued to regulate abortion, in part because the Supreme Court had kind of invited more state regulation of abortion. And the states further and further tested the limits of this new interpretation of abortion rights. And what happened is the court began to increasingly allow restrictions, regulations of abortion, as it did in Planned Parenthood, right? So in Planned Parenthood, the court upheld the informed consent requirement, the waiting period, the parental consent requirement. The only thing it didn't uphold was the spousal notification requirement. And then after that, states began to have bigger informed consent requirements, like trying to force women to look at the ultrasound before they underwent an abortion. States expanded waiting periods from 24 to 48 to 72 hours. They began to require informed consent be provided only by doctors and only in person. They began to ban certain abortion procedures, like what so-called partial birth abortion procedures. And then states began to pass what pro-choice folks call trap laws. These are laws that target abortion providers and abortion clinics specifically, so that abortions are a bit harder to come by. And as just a quick example of one of those kinds of laws and what the Supreme Court said in the aftermath of Casey, a case in 2016 called Whole Women's Health versus Hellerstedt was a case that involved one of these kinds of laws that specifically regulated abortion providers, abortion clinics. So this was a Texas law. It required doctors to have admitting privilege, abortion providers, physicians performing abortions to have admitting privileges at hospitals within 30 miles of an abortion clinic. And it also required abortions to become ambulatory surgical centers, which meant like widening hallways and doing lots of reconstruction of abortion clinics. And it put a lot of abortion clinics out of business, these provisions. It was challenged. The Supreme Court, by a 5-3 margin, said that the law was unconstitutional because it imposed unnecessary health regulations that had the purpose or effect of presenting substantial obstacles to women seeking abortion. There are more cases to go through that we could go through, but we won't because, again, time is short here. So let me bring us to Roe's End. And Roe's End is Dobbs. And let's talk about Dobbs and its implications. Before I jump into the case, let me just note that the composition of the Supreme Court changed quite dramatically, of course, from Roe to Dobbs, a very long period of time, but also from Planned Parenthood versus Casey to the Dobbs decision, right? From 1992 to 2022, a pretty good long time, the people on the court, the composition of justices changed quite significantly. And for example, in 2020, as you know, in September 2020, Justice Ruth Bader Ginsburg died. 8 days later, then President Donald Trump appointed Amy Coney Barrett to replace Justice Ginsburg. Amy Coney Barrett was confirmed right before the 2020 election. And then in May 2021, the court decided to take the Dobbs case and to hear it. So Dobbs versus Jackson Women's Health Organization, 2022. When the Supreme Court first accepted this case in May 2021, it agreed to review the constitutionality of a Mississippi law called the Mississippi Gestational Act, which banned abortion after 15 weeks of pregnancy, except in cases involving medical emergencies or severe fetal abnormalities. There's no question that under both Roe and Casey, the Mississippi law was unconstitutional because banning abortion at 15 weeks is well before a fetus is viable. And under the Roe and Casey framework, that would have been deemed unconstitutional if you were following Roe and Casey. The Supreme Court said it would only entertain one legal question that was presented to it. That question is whether all pre-viability prohibitions on elective abortions are unconstitutional. The court ultimately answered much more than that. And ultimately ruled that Roe versus Wade and Planned Parenthood versus Casey were no longer going to be the law of the land. So let me walk you through the majority opinion in Dobbs. It's pretty detailed. So my slides here are relatively detailed, but I'll move through some of these slides relatively quickly. but not this first slide. This first slide is pretty important, right? So the main thing that the court asks or addresses in its majority opinion is whether the Constitution confers a right to an abortion. And the majority, am I clear here? The majority, I'm just going back to the previous screen, it's authored by Justice Alito. It's joined by Thomas, Kavanaugh, Gorsuch, and Barrett. They compose the majority. Chief Justice Roberts concurs in judgment, but he doesn't join the majority opinion. He disagrees with large components of the majority opinion. So it's 6-3, but it's 5 who join the majority here. Okay, so this majority that's authored by Alito says the Constitution does not confer a right to an abortion. Why? The majority argues it this way. First of all, there's nothing explicit in the Constitution about abortion, but the majority grants that there are implicit rights that have been protected by the Constitution. But in order for something that is claimed to be an implicit right to actually be a protected constitutional right, it must be, quote, deeply rooted in this country, in the nation's history and tradition, and implicit in the concept of ordered liberty. So if there's a claim that a right is implicitly protected by the Constitution, the court says, the majority here says, we're only going to agree that it actually is protected if it's deeply rooted in this nation's history and tradition, and if it's implicit in the concept of ordered liberty. The court there is drawing on a precedent, Washington versus Glucksberg, in laying that out. The court proceeds, the majority proceeds and says, abortion, not rooted in our country's history and tradition. And there the court emphasizes that the 3/4 of the states at the time the 14th Amendment was ratified had made abortion a crime, and that extending of criminal statutes against abortion increased following the 14th Amendment passage into the late 1800s and into the early 1900s. So the court said it's not part of our tradition and history, and therefore it's not a protected constitutional right. The court also says that it's not part of a broader entrenched right to privacy supported by other precedents. So that here what the majority is doing, it's rejecting the claim that there is a right to an abortion part of this broader entrenched notion of protecting the right to privacy that includes freedom of making intimate and personal choices that are central to dignity and autonomy. The court rejects it and says, even if there is that kind of a right to making intimate and personal choices about that are central to dignity and autonomy, even if that is a right, abortion involves the destruction of potential life. And so abortion is unique. Abortion is different. Abortion is unusual by virtue of the fact that it destroys potential life. So this is key to the majority's analysis of why abortion is not a protected constitutional right. Still, the majority says, but there might be reason to continue upholding Roe and Casey because of precedent, because of stare decisis. So the court asks, does stare decisis, does precedent require us to reaffirm Roe and Casey? And here the majority says no. Adherence to precedent is not an inexorable command. That's language that has been used in lots and lots of earlier court cases. And the court says precedent is important, stare decisis is important, but it's not an inexorable command. It doesn't have to be followed in every case. So when does it have to be followed? Well, the majority here says there are 5 factors to consider, and it considers these 5 factors. I won't go again through this in all that much detail, but the first one's really important. One is the nature of the error of precedent. Here, what the majority says is if the error in precedent is really bad, is egregious, is terrible, well, that would lead us to overturn the precedent. So here the court says, the majority says, that Roe is like Plessy versus Ferguson, the case that established separate but equal doctrine with respect to race. And the court likens Roe to Plessy at a number of points in the majority opinion. The court says Roe was egregiously wrong. It was deeply damaging. It wielded nothing but raw judicial power. It short-circuited the democratic process, and that Planned Parenthood versus Casey perpetuated those errors. So the majority here is saying this was a terrible, Roe was a terrible ruling. It was mistaken. It was mistaken in so many ways. The court also says the quality of the reasoning in Roe was really weak and relied on erroneous history, erroneous precedent, and so forth. The court suggested that the workability of Roe and the rules that were followed Roe and Casey were not particularly workable, that it had a disruptive effect on other areas of law, and that ultimately there was an absence of concrete reliance interests. This is something that the court uses to sort of think through whether it should overturn precedent. The court will sometimes say, if there are strong reliance interests, if people really rely on these precedents, we should be cautious about overturning them. And the majority here says there aren't really concrete reliance interests at stake in this case. So we're not going to, the court says, the majority says, we're not going to shy away from overturning precedent because there isn't really justification for that. The court says or asks, should we avoid overturning precedent because it might, undermine the legitimacy of the court. It might shake confidence in public opinion of the court. And the majority says, no, respect for the rule of law is important, but that shouldn't stop us from overturning an egregiously wrong precedent. The court goes on to criticize the dissenting opinions. I won't go through all of this in great detail, but the majority is defensive about the dissent's critique that the majority is getting ready and calling into question all sorts of other precedents in Griswold and Eisenstadt, and precedents involving same-sex marriage and sexual intimacy rights. And the majority is like, we're not calling anything like that into question. This case is only about abortion. It is not about anything else. Abortion is a unique act. This is just about abortion. The majority also critiques Roberts' concurring opinion, saying that while Roberts called for judicial restraint, this case did not warrant judicial restraint, again, because of the sort of egregious character of the error in Roe versus Wade that needs to be remedied. So that gets the majority opinion to a place of basically saying, okay, a constitutional right to abortion doesn't exist. So how will the court examine abortion regulations? Well, like it examines any regulation that doesn't pertain to constitutional rights and any regulation that doesn't single out a protected class for differential treatment. That is, the court's going to examine it with the lowest level of judicial scrutiny, the rational basis test, rational basis review. And here the majority says states may regulate abortion as long as they have legitimate reasons to do so. Laws must be upheld by courts, like if laws regulating abortion are challenged, they must be upheld by courts if there is a rational basis which the legislature could have thought would serve legitimate state interests. So that's interesting language here. I just want to make sure you see what the court is saying here. If there is a rational basis on which the legislature could have thought that it would serve legitimate interest, even if the legislature was thinking something entirely different, if someone can identify a legitimate interest, then the legislature is permitted to regulate. And the majority here cautions other courts that are reviewing laws about abortion not to substitute their own judgments over legislative bodies. And the court says that abortion laws are entitled to the strong presumption of validity. So it's a very, very low standard, very, very deferential standard of review. That leads the majority opinion to say that the Mississippi law survives this low standard of review because Mississippi has an interest in protecting life. That's the interest it asserts. And it also asserts interests in not using, quote, barbaric practice that's dangerous for the maternal patient and demeaning to the medical profession. The majority opinion basically concludes then with this, quote, abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. So that's the majority. Very briefly, Thomas's concurring opinion in Dobbs is an opinion that has generated a lot of concern about the prospects of the future of not just abortion, but contraception, rights to marriage equality, sexual intimacy rights. And that's because Thomas in his concurring opinion wrote that the fundamental problem in past precedent on abortion is that abortion was found to be protected by substantive due process. And that Thomas basically says that the majority is not disturbing substantive due process jurisprudence in general. It's just focusing on abortion, and it's just focusing on the fact that there isn't a constitutional right to abortion. But Thomas thinks the court should disturb substantive due process precedent in all sorts of areas. And he says, in future cases, we, the court, should consider all of this court's substantive due process precedents, including Griswold versus Connecticut, Lawrence versus Texas, Obergefell versus Hodges. And he says that because substantive due process decisions are demonstrably erroneous, we, the court, have a duty to correct those errors as well. So Thomas is telling the world that he's ready to hear cases challenging the constitutionality of same-sex marriage. That is challenging these earlier precedents that have protected the right to same-sex marriage, the right to sexual intimacy, the right to contraception. He does allow that, well, maybe if we get rid of substantive due process precedent, there might be some other grounds in the Constitution to protect those rights. So we'll look at that when the cases come to us. But clearly he is calling for lots of cases to come to the court to challenge these other previously protected constitutional rights. Justice Kavanaugh, separately concurring, says, in addition to saying that the Constitution is neither pro-life or pro-choice and is sort of silent about abortion and is just agnostic about abortion, so we're going to leave it to the states. He also says, contrary to what Thomas says, he says Roe, overruling Roe does not threaten or cast doubt on other precedents. So he's saying that people shouldn't read it the way that Thomas is basically kind of suggesting that we should read what the court, at least Thomas, is signaling. He also says, Kavanaugh's concurring opinion says this, the court, he's applauding the court getting out of the abortion area, saying the court, quote, will no longer decide the basic legality of pre-viability abortion for all 330 million Americans. That issue will be resolved by the people and their representatives in the democratic process in the states or Congress. So he's saying that really this is going to be a matter just for the states and democracy and legislatures, and the courts aren't going to be involved in this anymore. Chief Justice Roberts, who concurs only in judgment, right? He writes, he does not agree with the logic of the majority, basically argues that the court should have used judicial restraint here and should have only focused on the question of whether all pre-viability abortions must be protected. And he argues that the court could have upheld the Mississippi law, which bans abortion after 15 weeks, without overturning Roe versus Wade, without overturning Planned Parenthood versus Casey. And so he's basically saying the court went too far. It didn't need to go that far to dispose of the case at hand. And by going too far, it didn't act with the appropriate judicial restraint. And then the dissenting opinion by Breyer, Sotomayor, and Kagan, who wrote in a joint dissenting opinion. These justices bemoaned the overturning of established precedent, bemoaned the overturning of a constitutional right to abortion and to bodily integrity and autonomy. They criticized the majority's opinion for its analysis of stare decisis and precedent, and also for requiring that what an implicit constitutional right, it only exists if it's deeply rooted in this country's history. On their view of this, the same could be said for all sorts of other implicit rights that have been protected and granted by the court. And by saying that, they are extremely concerned about the prospects for the protection for other rights that had been protected under a similar analysis as Roe versus Wade. So among the things they say in their criticism of the majority is this: one of two things must be true. Either the majority does not really believe in its own reasoning, or it does, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. And then they also criticized the court for overturning Roe versus Wade and Planned Parenthood versus Casey, basically saying that the only reason it's happening is because the composition of the court has changed and changed quite dramatically. And they're concerned about the legitimacy of the court and whether people will respect the court if it sways merely based on who is on the court. Okay, I want to wrap up shortly by talking about the implications of Dobbs. So I want to say a few things here about the implications. So one of the things is that people had talked about overturning Roe versus Wade and Planned Parenthood versus Casey as hopefully leading to less polarization and less partisanship by returning the abortion issue to the states and by allowing the states to settle abortion conflicts on their own and through democratic means. I think it's quite clear that returning abortion to the states certainly doesn't settle the debate. It doesn't seem to reduce conflict either. I think, in fact, we're seeing a tremendous amount of conflict in the states and also across states. Among the things that's unclear when you talk about the standard of review of Dobbs is what counts as a reasonable abortion regulation. Is it reasonable to ban abortion from the moment of conception? Is it reasonable to not allow exceptions for a woman's health in cases of rape, in cases of incest? What counts as reasonable abortion regulation is not something that I think the court will be able to avoid addressing in the future, as much as Brett Kavanaugh said that this is now going to be in the hands of states and democratic processes. I think we also are seeing real important issues pertaining to how pregnancy care is being affected by abortion bans. You're seeing story after story after story about women who are pregnant, who want to be pregnant, who want to give birth, who face extraordinarily unfortunate circumstances by having traumatic things happen to their bodies and to the fetus. And they are not being always given the necessary pregnancy and abortion care that they need. So you've got women who are pregnant who end up in situations where they no longer have a viable fetus, where the fetus, when it is born, it will die by virtue of massive complications. And they're not being given care. They're not being given abortions until they go into real distress, until they become septic, things like that. And women's health is being seriously harmed. Even women who want to continue with pregnancy, who aren't seeking abortion because they don't want to be pregnant, they're seeking abortions because they don't no longer have, for example, a viable fetus, or they are having some other significant medical circumstance arise. That's one of the biggest implications, I think, about the end of Roe that we're seeing playing out in states and in women's lives. We're seeing interstate conflicts over abortion as well. I think those will continue to play themselves out quite significantly. I think that returning the abortion to the states increases state level fighting over abortion and under state constitutions. So there's still going to be tons of litigation around abortion. I don't think that's going away. One example is an example that is unfolding right now. The example is the FDA versus Alliance for Hippocratic Medicine. I'm sure you've been paying attention to the news. The U.S. District Court judge in Texas, a gentleman named Matthew Kaczmarek, recently invalidated the FDA's approval of mifepristone, a drug used as a part of a two-step regimen to medically induce abortion. This drug has been approved by the FDA since 2000, and he has invalidated it. The Fifth Circuit Court heard an appeal of that. It rejected parts of the lower court's decision, but upheld other parts of it. And that case is right now before the Supreme Court, and we may hear something about it tomorrow. At the same time, the state of Washington versus FDA, a U.S. District Judge Thomas Rice ordered the FDA to retain access to mifepristone in 17 states and Washington, D.C. So you've got two district judges, U.S. district judges in different places coming to different decisions and conflicting decisions about an FDA-approved medication for ending pregnancy. That case has very interesting and complicated potential ripple effects for other FDA approval of medication. So again, this is not just about abortion. The implications of these cases have pretty significant ramifications in other areas of our lives. Also, beyond Dobbs, I just want to highlight a few things here before ending. That is that the majority in Dobbs, by requiring that an implicit right in the Constitution is only protected as a constitutional right if it's deeply rooted in this nation's history. They can say as much as they want and as much as they did that this is only about abortion, but the logic clearly extends to other rights, to contraception, sexual intimacy, same-sex marriage. It's really hard to see how that logic doesn't apply in all sorts of other contexts. And then, of course, you've got Thomas directly signaling and inviting challenges to substantive due process cases along those lines. And so I think that one of the main implications of Dobbs is that we are very, very likely to see further future challenges in all sorts of areas beyond abortion that are potentially going to be disruptive of constitutional rights that we have relied upon. And then more broadly, I think what we're seeing is an entrenchment of conservative jurisprudence, not just originalism, but definitely originalism, and then conservative jurisprudence around other things like deregulation, gun rights, all sorts of areas of jurisprudence. I think we're seeing, this is a piece of that. It is part of a broader trend that we are seeing on the court. I think that all of those things together, and then a number of other things that have been happening around judicial selection process, have implicated a dramatic decline in approval of the court and raised questions about judicial legitimacy. So, for example, following the decision in Dobbs, there was a decline in court approval. So in early July, only 38% of the public approved of the court, 61% disapproved. Those are very dramatic numbers from what has historically been a strong approval for the Supreme Court.